Hello everyone, welcome back to our channel US Immigration. We hope you're doing great. In this video we will talk about undocumented immigrants who have been in the US for more than 10 years without a deportation order can receive a green card. For undocumented immigrants living in the US for over 10 years without a deportation order, there is a potential pathway to obtaining a green card. This opportunity offers hope for those who have established their lives and contributed to their communities, allowing them to emerge from the shadows and gain legal status. If you are interested in this topic, so to get all the information, pay attention and watch the video through to the end. Please hit like and subscribe, and don't forget to push the notification bell for an upcoming video. So without any further delay, let's jump into the video. Although it is an existing program, it is difficult to qualify. You have to show the immigration judge that deportation will cause extremely high suffering to an immediate family member. For undocumented immigrants who have been in the United States for a long time, have no criminal record, and do not have a deportation order, there is an immigration benefit available that, if granted, qualifies them to receive legal permanent residence green card. But to win a case, they must meet a series of requirements in addition to those indicated, including not having a criminal record and demonstrating to a judge that their deportation would cause extreme and extraordinary suffering to immediate family members, such as a citizen or resident spouse or a U.S. child under 21 years of age. To qualify for this benefit, the immigrant cannot have a prior deportation order, says Alex Galvez, an immigration attorney who practices in Los Angeles, California. It is requested in immigration court, and only a judge can grant cancellation of deportation through the process known as 42 billion, he added. Immigration court reminder. The Office of Immigration Review posted a brochure on its website providing basic information about eligibility for cancellation of removal, a limited benefit, but one that is used in extreme cases. The reminder also warns of something important. It informs people about the limit of 4,000 immigrant visa slots per year, which may result in your cancellation request not being approved for several years, the American Immigration Lawyers Association said. The agency said that for now the brochure is only available in English, but will be published in other languages in the future. It also has QR codes that link to important web pages of both the EOIR and the Office of Citizenship and Immigration Services. Who qualifies for cancellation of removal? The EOIR indicates that this is a benefit intended for undocumented immigrants or foreigners who reside permanently in the United States but without legal permission from the government. The pamphlet stresses that if you meet certain requirements, an immigration judge can cancel your removal and allow you to remain in the United States. To qualify, the undocumented person must apply for cancellation of removal by filing a petition in an immigration court. If your spouse or U.S. citizen or legal permanent resident, green card, parent, or child would suffer exceptional and extremely unusual hardship if ordered to leave the United States. If you respect the laws of the United States and have not been convicted of any serious crime that automatically disqualifies you, makes you deportable and or inadmissible. If you are a person of good moral character and you have been lived in the United States for at least the last 10 years, key requirement, 10 years in the U.S. The requirement of at least 10 years of residence in the United States is a key element to qualify for the benefit of cancellation of deportation, says Galvez. He also said that in many cases, people detained at the border and then released and who remained in the United States do not have a deportation order issued, but in each case, the immigrant's file must be reviewed and it must be determined whether they meet all the other requirements to qualify. Galvez also warned that although this is an existing program, it is difficult to qualify. You have to prove to the immigration judge that the deportation of the undocumented person will cause extremely high suffering to an immediate family member. For that, you have to attach medical evidence. Galvez also warned that, in the event of obtaining a favorable ruling from an immigration judge, once the deportation is canceled, one will not necessarily receive residency immediately. In many cases, one has to wait 3 or 4 years, if not more. There are only 4,000 visa slots per year. EOIR explained that cancellations of removal are regulated and only 4,000 are granted per year. You will have to wait your turn. The immigration court warns this can take years. But he recalled that if the immigration judge approves the cancellation of deportation, the favored immigrant will be able to obtain a green card, permanent legal residence. Once he reaches the front of the line, when there is a visa quota available within the annual quota, he will receive a communication from USCIS. Galvez said that the wait is often uncomfortable, but there are not enough visa quotas for all those who win these types of cases every year. He also explained that the 42 billion procedure used to request cancellation of deportation of undocumented immigrants before an immigration judge is also used by legal permanent residents who, due to having committed serious crimes in the first 7 years, violate the terms of the green card and become deportable and or inadmissible to the United States. At what point does the judge issue a ruling? The key question in this process is when or at what point the judge rules in a cancellation of removal case. Jose Guerrero, an immigration attorney practicing in Miami, explains if the ruling is negative at that moment, but if the ruling is affirmative and grants cancellation of removal, the decision is withheld until there is a visa quota available in the quota of 4,000 per year. In the meantime, the favored immigrant remains legally in the United States and has the right to apply for a work permit, he added, unless during the wait he commits a crime that makes him deportable, because then he loses his right to stay in the United States. Asked what the immigrant should do once the ruling is issued, Guerrero said that he or she must make an appointment with the Immigration Service to be granted legal permanent residence green card, and that when he or she goes to the appointment, he or she must indicate the date of the final hearing and the judge's ruling so that USCIS can verify whether he or she has received the corresponding notifications regarding the ruling in the case and proceed with the granting of the green card. Jamie Barron, an immigration attorney who practices in Dallas, Texas, said that if there was a favorable ruling but the immigrant does not have the ruling in his hands, Barron can go to the court where the trial was recorded and request a duplicate of the order of cancellation of deportation issued by the judge, and then, with that duplicate, go to the Immigration Service and find out if he received the order to issue the green card from the court. Sometimes it takes a while. There were many delays during the pandemic. That is why it is good to press on, and if the order arrived but they have not sent you the green card, you can also claim and request a duplicate of the green card through Form I-90, he said. Gaining a green card after living in the U.S. for more than a decade can transform the lives of undocumented immigrants, providing security and new opportunities as immigration policies evolve. These pathways underscore the importance of inclusive solutions that recognize the contributions and aspirations of immigrants. That is all for today in this video. What are your thoughts on this? Please let us know in the comments section below. Thanks for watching the entire video. Hopefully the information is useful to you. See you later in the next video. Till then, take care.
Hello everyone, welcome back to our channel US Immigration. We hope you're doing great. In this video, we will talk about undocumented immigrants who have been in the US for more than 10 years without a deportation order can receive a green card. For undocumented immigrants residing in the US for over 10 years without a deportation order, a legal pathway to obtaining a green card exists but is notoriously challenging to qualify for. This process is known as cancellation of removal under Section 42B, allows undocumented individuals to apply for legal permanent residency. However, the path is strewn with strict requirements and limitations. To qualify, applicants must demonstrate that their deportation would cause exceptional and extremely unusual hardship to an immediate family member who is a US citizen or lawful permanent resident. This hardship must be substantiated with solid evidence such as medical documentation. Furthermore, applicants must have a clean criminal record, be of good moral character, and have resided continuously in the US for at least 10 years. Immigration attorney Alex Galvez highlights that the process begins in immigration court, where only a judge can grant the cancellation of deportation. Even with a favorable ruling, applicants may face a prolonged wait due to annual cap of 4,000 visa slots. This limit means despite winning their cases, many must endure additional years before obtaining a green card. The Office of Immigration Review provides resources outlining eligibility criteria for this process but emphasizes that the limited number of visas can significantly delay the final granting of residency. During this waiting period, successful applicants can legally remain in the US and apply for a work permit. The program also extends to lawful permanent residents who have committed certain crimes, allowing them to appeal deportation orders. Attorneys like Jamie Barron stress the importance of following up with the Immigration Service post-ruling to ensure the green card process moves forward, especially given potential delays such as those caused by the COVID-19 pandemic. Overall, while obtaining a green card through this route offers a crucial lifetime for undocumented immigrants, the journey is fraught with obstacles requiring perseverance, legal guidance, and patience. As immigration policies continue to evolve, the importance of creating inclusive and humane solutions that acknowledge immigrants' contributions become increasingly vital.